Well, folks, welcome to our third session in the state bid protest series. We're very, very glad you could join us. My name is Chris Eukins. I'm a professor at George Washington University Law School. I'm a professor in the Government Procurement Law program at GW. And this is the second summer that we've been doing this series. Last summer, we did a series on federal bid protests, and this summer we're doing one on state bid protests. We've really had an outstanding couple of panels over the last week. And we're going to this evening talk about potential areas of reform in bid protests. We'll be using the Model Procurement Code as a foundation for discussing reform, and then we'll be walking through the experiences in various states to understand how they've addressed reform in their own systems. I do want to stress that on Thursday we have a very different kind of session. On Thursday we're going to have a mock bid protest, and I'll talk about that in just a minute. So as I said, I'm a professor at GW Law School. I've been a professor since 2002. I run a blog called Public Procurement International, and that's where the materials from this program are located if you want to go look at them, including the recordings from the first and second session. There are a lot of background materials on there too. And if you have any questions, feel free to send me an email at ceukins@law.gwu.edu if you have any questions about the materials. Now, this evening, we'll be using the chat function. We won't be using the Q&A function in Zoom. We found that the Q&A function tends to create silos. So we are going to use the chat function, and the public chat will be recorded, and our panelists will be responding to the public chat, as well as I will be responding to the public chat as we go if you have questions. We do have, in all our sessions, we have a number of folks who are officials in various public bodies. I should stress that all statements made at any point are statements being made by the panelists in their personal capacity. So as I said, this evening we'll be talking about potential improvements to bid protest systems around the country. What's important to stress is that we're going to be talking about a relatively sophisticated bid protest function in Maryland. There are a lot of states, as you'll hear, that really do not have well-established bid protest systems. So this is a rapidly evolving area in American law. The bid protest function is rapidly growing around the country. And what we're going to be seeing this evening is snapshots of mature systems and also of systems that are still growing. We're going to have four guests this evening. I'm going to run through them quickly with you. We're going to be joined by Jennifer Dower, who is a partner at Diepenbrock, Elkin, Dower, and McCandless in Sacramento. She's the chair this year of the Public Contract Law section. And the Public Contract Law section in the American Bar Association is the main section for lawyers who are involved in public procurement, both at the federal level and then the state and local level as well. And the section has really worked hard in the last few years to reinforce its work at the state and local level, including, and very importantly, Jennifer has really played a pivotal role in this. Jennifer has helped launch a reform of the Model Procurement Code. The ABA rewrote the Model Procurement Code last time, and it was originally written in 1978, rewritten in 2000, and now it's going to be rewritten again through an effort through the Public Contract Law section, and Jennifer's played a very important role in that. As chair of the section, as she steps down as the chair in August at the annual meeting in Chicago, she'll continue to be involved, thankfully, with the Model Procurement Code. She has a BA from UCLA, a JD from UC Davis, and at UC Davis, she was Order of the Coif articles editor on the UC Davis Law Review. She's going to be joining us, as I said, after the break. She's involved in prep right now in litigation. We also have Tom Kenny, who's the co-chair of Kutak-Rock's healthcare litigation group and the National Government Solutions Group. He leads the firm's state and local bid protest team, so he's got extensive experience working on state bid protests. And he and I have worked on this issue for many years, and Tom is working on the Model Procurement Code reform efforts of the American Bar Association. He has a BA from Marquette and a JD from Catholic, where he's the notes editor on the Catholic Law Review. We're also joined by Ed Fox from Kutak-Rock. He has litigation practice focused on government and regulatory disputes, white-collar defense, and federal and state procurement disputes. He has a BA, an MA, and a JD from the University of Nebraska. In law school, he was the executive editor on the Nebraska Law Review. We also have Michael Carnahan, who is now one of the newest members of the Maryland Board of Contract Appeals. He was previously the clerk for the board. We're really excited to have him. And Lydia Hoover, who was a panelist last week, is with us as well. Lydia Hoover has been very, very kind in introducing us to the members of the board and helping us better understand Maryland state procurement law. We've been very, very grateful for that. Mike was previously the chief of staff for State Senator Michael Collins in Maryland. He was the president of the educational-based Latino Outreach Organization, and he's been with the Maryland State Board of Contract Appeals for 20 years. And as I said, he was just named by Governor Hogan as a member of the board. He has a BS from the University of Maryland, and he's working on his MBA now. So we're very, very glad to have Mike. So he has a firsthand knowledge of how a sophisticated, mature board works, and he'll be sharing that with us later on this evening. Okay, so our next session, as I mentioned, is a mock bid protest, and we've had a little bit of a change here, where one of the teams doesn't have enough lawyers. So old Professor Eukins is going to join one of the teams on Thursday, and I decided to put my nice lawyer hat on for this presentation. So the good thing is it's with the intervener team, and I'll be working with Keith Montoya on that one. The good thing is, as an intervener, as a representative of the awardee contractor, I will have an opportunity to talk about where some of the gaps are in the model procurement code, because as you can guess, I buried them inside the problem, and the fact that I can argue them, then we'll be able to bring, Keith and I will be able to bring those problems to the surface. I've revised the problem, which is posted on the website. If those who are serving as judges on Thursday, the revised problem I only changed the procedural aspects. The substance of it remains the same, and it really is a deep dive into the model procurement code and its model regulations. So I'm looking forward to that on Thursday. So this will be the teams on Thursday, and then on the intervener, I'm going to be joining Keith and making that third argument. We'll be splitting the arguments between us. Each of these teams is going to split the arguments between us. And we originally had a protester for a civil society organization, a public interest organization. We're not going to have that. We're just going to have the classic structure of the protester, the agency, and the awardee intervener. I want to just talk very briefly about the model procurement code, so we have a lot of time to chat with Mike Carnahan about what goes on in the board. So this is something I talked about in the first session. These are the basic elements of analyzing a bid protest system, and this was from an article that was written by Dan Gordon, and when he was teaching at George Washington University. He was the administrator of federal procurement policy in the Office of Federal Procurement Policy in the White House. And then Dan came back and taught with us, and now he's retired, but his articles are incredibly important. Actually, two of his articles are very important for Thursday's problem. One is, what are the elements of a bid protest system? And the other is an article laying out what are the issues in organizational conflicts of interest. And organizational conflicts of interest are an important part of Thursday's practicum, because they're an area of law that the Model Procurement Code, revised in 2000, doesn't really address. But since 2000, there have been very important developments in organizational conflicts of interest law around the country. So that's why we included it in the problem. So the basic elements of the questions in any bid protest system, and we joke about this article that Dan really wrote this for developing nations that are developing their bid protest systems, because bid protest systems do exist all over the world now. We had Ian Hargreaves, as I mentioned in the first session. He wrote an article, or a note. Ian Hargreaves wrote a note for the Public Contract Law Journal on 98 different countries' bid protest system, analyzing standing. I mean, the growth of this area has been fantastic around the world. And so the questions that have to be answered is, who has standing? And that's an important issue in the mock protest problem. Where the protests will be heard, whether or not it's going to be heard inside an agency or inside an independent board, which is what the Maryland board is, an independent board, or it's going to be heard before a court. Many countries rely on courts. In fact, the OECD did a study a few years ago, did a survey internationally, and found that actually most countries rely on the first option, which is agency level bid protests. The idea of developing an independent board like Mike Carnahan works at in Maryland, or the GAO, which is an independent agency, or you relying on the courts. Those are lesser options around most of the world. The third is what may be protest. And as I mentioned in the first session, sometimes you have laws like the UN Model Procurement Law originally in 1994 walled off a lot of issues from protest. And that's really not the norm internationally. And that's why when we revised the UN Model Procurement Law, we opened it up and we said that almost anything is protestable as long as it's a regular part of the competitive process. Next question is whether or not a contract will be final once it's entered into, whether or not there'll be a lock. In some systems, once there's a public contract is in place, you can't undo it. So once the contract is signed, you're essentially making it impossible for a protester to ultimately win the contract because there's a lock. And that's a really important issue. Another issue is the question of the time limit for how soon does a protest have to be brought? And that's an issue, just to give away an issue in the mock bid protest. That's an issue in the mock bid protest. And then relatedly, how soon does the decision have to be made? And we'll be talking about that a little bit as we're talking about different forums around the country later in the session. The time to decide sounds kind of silly, but it's actually a really important question because as you compress the time to decide, certainly the experience at the federal level was if you compress the time to decide, like the General Services Board of Contract Appeals that heard computer protests until August 1996, the GSBCA had a 45-day timeline. So the only people that could litigate those bid protests were the K Street law firms. They made a fortune off those IT protests because you needed to have an enormous number of lawyers that could be pushed into a matter really quickly to run through all the forms of discovery, depositions, et cetera, interrogatories, document requests, get it all done in 45 days. So the compression of time can sometimes have unforeseen consequences. It means that there's less disruption of the procurement process, but it also means that it creates a limitation on who can actually handle the bid protests. Only the largest shops can do it. Another question is whether or not you stop the procurement, whether or not there'll be a stay of the procurement. We'll be talking about that. Are there abusive protests that are going on and how to deal with that? GAO has really struggled with that, how to deal with protests that seem to be without any foundation. A more marginal question, a more difficult question is whether or not when incumbents bring protests, whether or not they're doing it just to prolong their existing contracts. And that's something that we're working through on a study that I'm doing with the Defense Department right now through the Acquisition Innovation Research Center at Stevens Institute of Technology. That question keeps coming up. The data that was gathered by RAND on federal bid protests a few years ago indicated that it's really not that big an issue, but it's something that we're going back to and something we've been focusing on in our interviews in that study. Whether or not, what kind of evidence will be allowed, so what kind of administrative record will be allowed is a big issue. We'll be talking about that. And one of the interesting things that's emerging in the federal study is a growing question about whether or not, in terms of the administrative record should, for all three forms, should be the same. It should be a standard administrative record that would be similar to something under the Administrative Procedure Act at the federal level, just the standard contract file. And if we do that, and this is something Lydia and I have talked about, if we do that, if we have a standard administrative file for all three fora, will that mean that it's possible to use the agency fora more commonly? It's an interesting question pivoting on the record. We'll talk about that over the course of the session today. Another question is the winning percentage. The GSBCA largely collapsed as a bid protest forum in 1996 because there's a perception that 50% of the cases were wins. Very high win rate creates a downward spiral where more wins encourages more protests, encourage more, it goes down and down. And there's a protest system in a Far Eastern nation that I'm not allowed to name, but the hint is when I've lectured there, it was 2 o'clock in the morning, my time. But in this nation I'm not allowed to name, they have an 80% protest rate and a win rate that's close to that. And that's because the agencies don't really put up any defense. They just flush it through. And then the board gets this protest and has no way to really analyze what went wrong except what the protester says. So there's a win and it's a downward spiral. It's basically a bid protest system. It's like hyperinflation. It's a bid protest system that's arguably out of control. It's really interesting. That's why the study is being done that I got involved in. The European Commission has come in and helped them rethink their bid protest system. Power to enforce. Should a board or should a court or should an agency, what kind of power should they have, especially an independent board? GAO has no power to enforce its decisions, but if the agencies ignore the GAO's decisions, they can get in very serious trouble with the appropriators. That's another important issue to consider. As I said, there are three main fora you see around the world, either the procuring agency or an independent administrative board, like Mike Carnahan works at, the Maryland board, or a court. So these are the three main options. And as you may have guessed, procurement geeks like me, we really push the independent administrative board. And there's a very simple reason for that, which is the procuring agencies oftentimes don't publish reasoned decisions, or they publish very short decisions. A court may not really understand procurement law. Only the independent administrative boards really understand, have a view of the landscape of the procurement system in a jurisdiction, and they can help map out the law. And that's why procurement people like me, old procurement professors, really like an independent administrative option, because it helps develop the law in any given nation. They really have a view, a 5-year, 10-year perspective on where the system's going, and they can drive the system in that direction. And you see that all over the world, all over the world. So one of the things we're struggling with in this study that we're doing for the congressionally mandated study that we're doing of federal bid protests in the Defense Department is, what's the purpose of a bid protest system? And what we're kind of boiling down to now is it has two main purposes. Bid protests seem to have two main purposes. One is to address contractors' concerns, because if contractors feel like they've been mistreated and the system is unfair, they won't come back to the marketplace. And repeat players are really important in a public marketplace for hundreds of reasons, but they're important. And so I can show you examples of where markets have broken down and contractors haven't returned, and those markets really are in very, very bad shape very quickly. So one is to make contractors feel like their interests are being addressed. And the second purpose is to serve as an early warning system for officials in a procurement system. Something's going wrong in the procurement system, and it has to be addressed. So what we're really studying in the federal study is, how can senior leadership in the Defense Department use bid protests as an early warning system? That's what we're really trying to work out. And a lot of that has to do with the transparency of the system, transparency of the record, transparency of the decisions, so that there's a good red flag system working. So that seems to be the second purpose of bid protests. And together they maintain the integrity of the procurement system. That seems to be the goal. Everyone can reach consensus on maintaining the integrity of the procurement system through bid protests, and then you work to these subsidiary goals, which are important. Each is important on their own. For example, in some systems, Israel places a lot of emphasis on the dignitary interests of the bid protester, the due process interests of the contractor. So different systems put emphases on the different purposes, but they are each of them is really important. So I just want to talk a little bit about the Model Procurement Code, because it is a backdrop to our Thursday problem. And it is also, these points that I'm going to be talking about are backdrops to the reform that we'll be talking about in the Model Procurement Reform effort through the ABA. And if you're interested in becoming involved in that effort, please let us know. Right now, the steering committees are meeting on the Model Procurement Code reform effort. And over time, that process is going to accelerate. So if you're interested in dealing with particular issues within the Model Procurement Code, it's a very good idea to get involved now, including on bid protests. So one of the questions on bid protests is, should we have a broader rule of standing for bid protests? And the rule here in the Model Procurement Code is really the same one we see at the federal level. You have to be an actual or prospective bidder, offerer, or contractor. If you're a contractor, if there's a question of a material change in the contract down the road that really should have triggered a new competition, then the contractor in effect becomes involved in a bid protest at that point. But let's put that to one side for 1 second. So really what the federal rule looks at and what the model procurement looks at is whether or not you're a bidder. Are you a bidder? And that's a relatively narrow perspective. There are some systems that in the United States that give any taxpayer standing. There are systems in the nation of Georgia, anybody who joins the electronic procurement system that can bring a protest, including me. I've joined the electronic procurement system in Georgia, so I can file a bid protest there. I asked a friend of mine there, I said, Tato, if could I like sell that vote? Could I get someone to pay me money not to protest? And he said, I don't want to talk to you anymore. He basically shrugged off that question. But it's a question in a corrupt society. I mean, who could be bought off to not bring a bid protest? Anyway, in France, unions will have standing to bring a bid protest. Different legal cultures will approach this differently, including the U.S. Court of Appeals for the Federal Circuit. So the supervisory circuit for this area of federal procurement, in a case called the Seacher's Health, Judge Dyke, really respected administrative law lawyer. Judge Dyke said you didn't have to be a actual bidder as long as you were encountering issues were likely to occur on a recurring basis in other procurements. So he's really sort of started to broaden the aperture at the federal level, really, I think, along with the perspective of a whistleblower. We wanting to identify good whistleblowers, people who are going to encounter contractors, vendors who are going to encounter the issue over and over again. Let's let them in the door as protesters, because we want them to present a cogent argument, to present the problem cogently, and to be invested in it. I think that's the key. Who can present the problem well to the board or to the court and is invested in it heavily enough that they'll actually describe it completely and fairly, so that it becomes a whistleblower type system. And that's really key to understanding, I think, the way bid protests work. I clerked on the Second Circuit up in New York, and we had a guy named Officer Dolinsky, and he kept pulling cocaine out of people's bags in Brooklyn. He did it at the beginning of this my work there, and at the end of the year, another case came up with the same Officer Dolinsky. He kept pulling cocaine out of people's bags, and those cases, those criminal procedure cases, they were essentially whistleblower cases. They were criminal defendants who'd been sentenced to massive drug sentences, saying, look, you got a problem. You have somebody who's reaching into people's bags in Brooklyn, and this is a problem under the Constitution. So these cases become whistleblower type cases. The same thing is true of bid protests. They're a whistleblower type system. Okay, so what the Model Procurement Code assumes is that either the chief procurement officer or the head of the purchasing agency or some other designee will hear bid protests. This is an issue we struggle with in the federal system. I wrote a report for the Administrative Conference on agency level bid protests. And what's emerging in the federal system is the idea of having an agency protest officer. I was one of the most interesting parts of my interviews of people for this administrative conference report. Senior lawyers love this idea. They said, agency protest officer, that would be fantastic. It's a lawyer with a different hat. He's called an agency protest official. He sits over there and he's called an agency protest officer. So so he can act independently. And he keeps statistics on matters that are coming in, just like a compliance officer would in a corporation. The agency protest officer can start registering where there are recurring problems in the system. So the senior lawyers thought this was a great idea, not to have the chief procurement officer sitting or his designee, another procurement officer, but instead having somebody called an agency protest officer. A really interesting question and something that we'll be dealing with in the MPC reform. Okay, the next question is the form of a decision. And this looks pretty straightforward. Promptly issue a decision. That's what the Model Procurement Code says. So does FAR 33.103, which governs agency level bid protests. So what does promptly mean? Well, promptly in some federal agencies means till the end of time. So protest will come in and no, it'll never get decided because all the rule says is promptly, okay? And they can go on forever. So this rule promptly, while it leaves flexibilities in the agencies, in some cases, it can create really a black hole that protests that go to the agencies might never get decided. And that raises serious issues in the legitimacy of the system. Another reform that I hope Lydia and others work with is the protester is referred to as a Protestant, okay? Change this, Lydia, for God's sake. As a Lutheran, I find this incredibly offensive. It's a protester, not a Protestant. All right. The finality of the decision means that the challenge here for a statute is to try to put all these pieces together. If a protester in concept, a protester could go first to the agency, then to the independent agency, and then to the courts. And that's true at the federal level as well. Here you see it on the Model Procurement Code. It creates a sort of spaghetti statutory language, which is unfortunate, but it's inevitable. It's because you have to fit together these three. An important question we'll be talking about this one. We talked about in an earlier session is it enough to trigger the next round of appeal if you get a non-decision at the agency? At the federal level, it's enough if there's no decision, but the agency does something decisive that says it's basically rejected the agency level bid protest. So it's a non-decision. And GAO has ruled that a non-decision can trigger the deadline. Mike, you're not a lawyer, but I have to tell you, malpractice haunts lawyers. That's all they think about all the time. And so if you go to a forum where your trigger for an appeal is a non-decision, it's like you're sweating all the time. Oh my God, has it been triggered? Oh my God. You're trying to guess from nothing. And that's really, really scary for a bunch of risk-averse nerds, which is what lawyers are. And so having that kind of non-clear decision is a really bad idea. And Lydia, I hope the MPC makes it very clear that there has to be a decision in order to trigger the next round of appeal if the protester is climbing the ladder, so to speak. Stay of the procurement during the protest is presumed under the MPC, and so the idea is that you're preserving the contract for a subsequent award, but you're allowed to override, and that's the same as true in the federal system. An agency official, if there's really pressing circumstances, can override, so continue. But the override again is the exception, not the rule, because we're trying to entice a whistleblower to come forward with a bid protest. That's what the protester is. He's a whistleblower, and what do we want to pay him? We want to pay them the prospect of a contract. We don't want to pay them damages. Most contractors, when you talk to them and say, what do you really want? Do you want to get lost profits, which is what you can get in Europe? Nope. We just want to get the contract. In fact, it was interesting, it's the only place I've seen where there's really a lot of energy behind damages that go beyond the contract is in an authoritarian country that I shall not name, but it's very big and it's in the Far East. And in that country, government lawyers argue for large damages, because if you bring a protest against the government in this large nation that shall not be named, you can get in very serious trouble with the government. They don't even like the word protest there. So the agency lawyers understand that there have to be more enticements, more lures to bring protesters forward, and that's why they actually favor. It's a counterintuitive. Agency lawyers favoring large damages. It's because they want to know where the failures are. They want bid protests. There's the entitlement to cost. The MPC tends to be very stingy about this. And Lydia, we're likely to talk about this a lot during the MPC reform process, whether or not there should be other damages available. For instance, how easy should it be to get costs? It's very clear under the MPC, you can't recover profits. You can't recover lost profits. But as I said, in some systems in Europe, it is like in the United Kingdom, you can recover lost profits. They're revising post-Brexit their bid protest rules, but they're likely to continue. The bid protest law is likely to continue with lost profits there as well. Okay, so here you see, this is a very important part, and this is a very flexible, and as Americans, we take it kind of for granted. Oh, if there's a bid protest and it succeeds, then we can terminate the existing contract for convenience and just pay the termination for convenience costs. That's not true in many countries. Under Roman principles of law in the European Union, that lock takes place, and you can't tear the existing contract, you can't tear it apart. So the Europeans have put in a kind of a weird provision, a standstill provision that's now taken off around the world, which is you give notice of award you can only award 10 days later. So the lock can't occur for 10 days. So the Europeans said, no problem. We've solved this whole problem with lock. We've created a 10-day standstill. Americans say, you're insane. That means what in the US system, 0.3% at the federal level, 0.3% of contracts are protested, 0.3%. In Europe, 100% of the contracts are delayed for 10 days. What kind of inefficiency does that create by delaying every single contract for 10 days? That's where this is the American-European debate about those stays. The court review is this is a standard part of the third step of the ladder: agency, independent agency review, then courts if a contractor decides to go up all three steps, and the MPC contemplates that. One of the things that's going to maybe a little controversial, and as we review the MPC, is when a protest has to be brought. Under the MPC, the protest has to be brought within 30 days. In the federal system and under the UN Model Procurement Law, after endless tedious debate, we decided to make the UN Model Procurement Law the same as the federal rule. Under the federal rule, competition protests, solicitation protests, can be brought up until the moment that proposals are due. And the reason for that is if you create a 30-day deadline, 10-day deadline, or whatever it is, that's earlier, it means everybody has to read all the solicitations all the time. And that's not really efficient. The idea is to let the process unfold, let protests come at the very last day. A protester who waits until the very last day is foolish, because it means he's really going to antagonize the agency. So that we don't see a lot of last minute protests in the federal system, but the rule is technically that you can protest right up until the last day the proposals are due. Okay, this is just the ladder laying out the appeals process with clear. The MPC is calling for clear notice of when you have to take the next step, and again, this is the review process going up the ladder. Okay, I wanted to turn it over now to Mike to talk about the Maryland State Board of Contract Appeals. Mike, the floor is yours.
Thank you, Professor. I appreciate it very, very much. And thank you for not only including me, but including our agency and also member Kreis. He'll be participating on Thursday, and I know he's very much looking forward to that. Also, a big thank you to you, Lydia, for connecting us and for getting us involved, because expanding your horizons, learning more, it can only serve to enhance what you know and what you do. And so it's a great pleasure, privilege, and honor to be with you all. I wanted to give you a quick history to start out. So if we could go to the next slide, Professor. We talk about the beginning. What I mean there is that in the state of Maryland, we have this sort of culture of coming from a corrupt government when it comes to procurement. People have heard of Spiro Agnew for a reason, and not just because of his political ambitions and aspirations and successes, but because he was one of those people who took advantage of the system and used it for his own gain. And so there was sort of this hodgepodge of rules, and there was no specific procurement law that laid out how things are to be done. And so that you just found this really, really kind of hodgepodge mix of things in the law. And so that allowed people to use political favoritism to give contracts here and there. And it wasn't until 1980 when the legislature passed a law that said we're going to have a specific body of rules that govern how procurement is supposed to be done in the state. And so this is the Maryland Procurement Law. It began to be used July 1st, that's our fiscal year, July 1st, 1981. To learn more about all of that stuff, there are a couple of really great publications that I want to draw your attention to, and maybe Lydia can share some links if she has them. I'm not sure. These are from two University of Baltimore Law Review articles. Lydia and I have known each other for a long time, and she used to work at a law firm that to this day appears before us regularly, and Scott Livingston is the primary person who comes before us. And he wrote an article that was about the fair treatment for contractors doing business with the state of Maryland. And as we go on, I'm going to explain why that's important to our board and what that means to us. The next thing, which really lays out kind of how things work, is a 1999 article that was co-authored by Scott Livingston and Lydia Hoover. And this one is the principles of Maryland procurement law. And so those two things really give you sort of a background, a history, and they sort of build towards what we became, our board became, and what we do. So to backtrack just a step, on July 1st, 1978, the Maryland Department of Transportation started to use what it called a Board of Contract Appeals, which was created by the legislature. That was an effort to start heading away from that corruption. And so it was to give a sense of fairness to contractors. Contractors are saying, we want to do business with the state, but we're not exactly feeling it. We're not feeling like we're being treated fairly. And so what can you do to help us out? And so the legislature created this board. The problem is that that board was still under the purview of the Secretary of Transportation. And the majority of state contracts at that time went through the Department of Transportation. So go forward, the legislature creates the new procurement law, and then they say, well, if we're gonna have a new law and it's going to be to dictate how all of procurements can be done in Maryland, perhaps we can build our own Board of Contract Appeals that's independent. And so July 1, 1981, the Maryland State Board of Contract Appeals started. And so it superseded the previous MDOT Board of Contract Appeals. And the mission now is to really invite the business community in, contractor community, and say, we really want to treat you fairly. We want you to have a fair shake. We want to give you every opportunity. So here's this board that now has been removed from MDOT. The board doesn't answer to anybody. The board is specifically known as an independent agency of the executive branch. To this day, no one from any agency, not the governor's office even, nobody calls us to say, where is this? What are you doing? Hey, what do you think's going to happen there? We're off limits. And so people don't even try to do that. There was one time when a lobbyist who used to be a lawyer approached me outside of the building and said, hey, can you pass along this message? And of course, I did not and could not, because that's the whole point of being an independent agency. You're free to make decisions that are correct based on fact and law, and you're not intimidated. You're not even intimidated after you've written a decision, and even sometimes you'll find that the various governors have complained that they didn't like the decision, but they didn't tell us, go back and change it, and they didn't contact us and say, hey, you're out of line here. So it was really crucial, I think, to the business community and to really enhancing competition in Maryland procurement that this independent board be created. And we'll talk about that a little bit more in a couple seconds. But I do want to point out that if I understand correctly, the original structure of the Board of Contract Appeals was partially based on the 1979 Model Procurement Code from the ABA. So I think that's an important thing to note. We do, if we could move on, Professor, to the next slide, please. We do 3 things now. Originally it was 2 things. It was bid protests and contract disputes. And I should have included the 3rd thing in here, but it's a brand new thing for us, and that is licenses. So we do bid protests. We do contract disputes, and I think everybody probably knows what those are. Obviously, everybody knows what a bid protest is, and so contract disputes are when there's a dispute after during the execution of the contract or after the work is done. There's a problem. Maybe there was a different site condition, and so they go back to the state. The contractor goes back to the state and says, "Hey, can we get an equitable adjustment here? Can we have some extra money?" And the state sometimes says, no, you should have known about that. You should have done your research, your own due diligence. And so they battle it out and end up coming to us, and we try to help them resolve it. And much of the time, 85 to 90% of the time, those things resolve themselves, because once they follow our process and all of the cards are on the table, it's much easier for everybody to understand their position, and it's much easier for them to go ahead and work things out, knowing that it's just going to be a continuous expense if they go forward. So fortunately, a lot of those do settle. Almost no bid protests settled, though. So that is one of the things that we focus most of our energy on. In fact, the Maryland law says that we have to prioritize bid protests over contract disputes. And so literally there's a solicitation out there for planting flowers in the springtime. And so we got to get this thing done. So we've literally had to push a contract dispute down the road a little bit and take that time to spend on that bid protest. So bid protests are really what it's all about. It's about, keeping the train moving, and it's about getting the best bang for your buck, to put it in layman's terms. And so the other thing that we do is a brand new thing for us. The legislature a couple of years ago gave us jurisdiction over licenses, and specific licenses. And these licenses are sports wagering licenses. And they said, we want you to prioritize these even over bid protests, because they should be a little bit more simple, because there's no actual protest process. It's not competitive sealed bidding. It is people apply, the commission evaluates, and then they make a decision. And if somebody is denied a license, they can come directly to you, no protest, no nothing, they just come directly to you. And so what we did was we determined that we would treat those as bid protest denials, so that we could use, in essence, the same regulations that we already have in place to keep things moving. So the next thing that I want to talk about, if we can move forward. Oh, yes, sir.
So one of our challenges, Mike, is to teach young officials and young lawyers how to deal with things like when you're approached outside a building, and ask questions like that. So I actually when I was the Justice Department, I got asked, a deponent who was a contractor. He, in the middle of the deposition, he invited me for a ride on his boat. I think this might be a bribe, but I'm not sure.
Yeah, that's great. That's great. We have to be very careful. Even in the legislature in Maryland, they a while back, maybe 20-ish years ago or so, they passed a rule that says that not only can lobbyists not give gifts over a certain dollar value, like $20 or $25 to legislators, they also cannot give them to the staff. And until then, the staff were like, do whatever you want. And then they even went a step farther and said, you can't take an individual legislator out for a lunch or a dinner, but you can host an event where there's a delegation or a committee and that kind of thing, to keep it all on the up and up, so there's not this one-on-one behind the scenes operation going on. And so that's a perfect example. The gentleman who approached me outside, I'm sure he would have happily taken me for lunch or dinner or whatever else I wanted to do. But yeah, absolutely no chance I was passing along his message. And to this day, nobody's ever heard the message.
What I did is I called the ethics officer, and to the time it took me the ethics officer to walk over, my ethics officer from the Justice Department, it gave me time to think. And when she came over, I had another lawyer in the room. I had somebody I can consult with. Mm-hmm. So I could think through the criminal aspects with her. And that was really very helpful. Just on this dual jurisdiction, we talked about this with Lydia, and I'd really like your perspective. So a state thinking about setting up a new system, it might think about having a joint bid protests and contract appeals, just like the Model Procurement Code does. How do you feel about that dual jurisdiction?
So I will tell you, I did listen. I wasn't able to tune in on Thursday, but I did go back and listen to the whole thing, including Lydia's brilliant points of views and perspectives. But Lydia is, without question, one of the most brilliant lawyers you're ever going to meet. So she had really great points throughout that discussion. And I would say that for me, just like she said, it's the only way I've ever known it. And so I wouldn't know what it would be like to do anything differently. I have, from my early days as the deputy clerk, and when I joined the board in July of 2002, I was immediately presented with both of those by the gentleman who was chairman at the time, Bob Harrison, God rest his soul. True gentleman, true person who really understood the concept of hearing, because he loved to listen, and he would give people as long as they wanted to have their say, so they felt like they got their day in court, so to speak. So he presented both of those things to me immediately and said, now here's two different things that we do. And so you're gonna have to get used to handling both of these things. They have different rules, different deadlines, different letters, different scheduling, different procedures. A contract dispute can go on for 2-3 years. And so contract claim appeal, a contract dispute, as we call it, can go on for many years. A bid protest has to be done as quickly as possible. Now, obviously, there's discussion that I heard in the other sessions about how quickly they're done at the agency level, but we're the next level. So you don't like the decision you got at the agency level, you get to appeal that to us. So your bid protest is denied, you come to us. Now we've got to jump into action. When it comes to a contract dispute, you understand that the timeframes are much more elongated. And so it's not as pressing, but when a bid protest comes to the door, you sort of kick it in gear and you really start to focus and you lay out your schedule and you put your calendar reminders in place. So I have no problem dealing with both of them because it's all I've ever known. And I understand completely how to treat them as two different things. And I would say it's akin to growing up in a household with two languages. You understand them both equally because you learn them at the same time.
Do you think that one of the criticisms or concerns about GAO is that GAO, which doesn't deal with performance issues, doesn't really appreciate performance risk and doesn't really expose to contract administration issues? Do you think it helps to have members of the board exposed to both kinds of issues?
I think it really does, because it gives us a great, maybe greater is the wrong word, but I'll use it anyway, greater perspective. It gives us a different angle, a different perspective than someone else might have, because and honestly, when we get a little further along, what I was going to say is the Maryland procurement process is really quite a good one. But I think that one of the things that we need to realize is when it comes to getting to us, we're seeing what is typically the worst of the worst. So we've got experience with seeing some really terrible twists of fate in the way that contracts have worked out. And we've seen, it becomes personal and people really get fired up and that's not productive for anyone. And so if we can somehow help along the way, whether it's through helping, by writing a decision that somebody reads and it adjusts policy, then that's great because we want to keep the contractors engaged. And going from the other angle, which is what you were hinting at, is that when we're hearing a bid protest in particular, we can sort of envision the kind of problems that could be created down the road. And so when you hear it about it, sometimes when you hear about a cancellation, you say, okay, what was that about? And then sometimes it turns out that a cancellation is the best thing possible because it avoids these problems that could come down the road by giving the agency a chance to revamp that solicitation and sort of start over. On the negative side, I think that sometimes not only does that cause a delay in the process, obviously, but it also, we have to remember that contractors put a great deal of time, effort, and money into preparing their responses to these solicitations. And so now you can't just go back when there's a do-over and trust that somebody told you, oh, we only added this. You got to do your due diligence. You got to go through that whole thing line by line again. So there can be negatives to that. But I think that when we look at it, we say, all right, that's reasonable. It makes sense. We've seen enough bad out there that sometimes taking a step backwards is a good thing. And so it gives us a different perspective and helps us to more fully understand the entire process as opposed to just the formation part of it. Moving along, I've already kind of talked about fairness and the point of being an independent board. When we talk about fairness, and as I referred to earlier, the publication about fairness to contractors doing business with the state of Maryland, I come from a legislative background where one of my roles was to try to resolve issues for constituents. So they can't get through to somebody in the bureaucracy. And so I get to call the secretary's office and figure it out for them. And then, of course, approach it from a very, very appreciative aspect. And can you help us out? Can you help us? So for me, it's always been about a sense of fairness. And what people need to realize, though, is that it's fairness in both directions. So fairness, first, in terms of creating robust competition, robust, not my favorite word, but it's meaningful here. It's kind of overused, I think, but it's true. You really want that robust competition so you can get the best services or products at the best price or the best value. Sometimes price isn't the best value, as we all, I'm sure, are familiar with. So in doing that, we have to look at it and say, we want the contractors treated fairly, but we also have to look at it and say, well, who else needs to be treated fairly? Well, the people paying the bill. So we have to be fair to all parties. And frequently I refer to it that way. The people paying the bill are the taxpayers, because when we say the state, we think of the state as a behemoth entity. And really what we're talking about are agency needs that are responsive to citizen needs. So the agencies are responsible for buying products and services that are meant to help govern and help benefit the citizens. So we need to be fair to all parties. On that note, when contractors call in, we have to remember that a lot of times those people are the citizens of Maryland who are taxpayers. And so somebody will call in and they'll say, I've never done this before. I've never had this problem. What do I do? Well, the first thing I tell them is get an attorney. You know, anytime you're in a situation like this, you should have an attorney. In fact, if possible, before you submit your bid or proposal, have an attorney look over it and consult with you and help you to realize, as Lydia talked about last week, how you can avoid a bid protest, right? How you can avoid that situation. So, or the need for that bid protest. So when people will call in, I'll say, get an attorney, but in the meantime, you've got 7 days from when you knew or should have known of the reason for your protest, the basis for your protest. So even if you have to do it yourself, here's the COMAR site. I can't tell you how to do it. I can't give legal advice, but if you go to this COMAR site, it tells you what to include. Send that bid protest in. If you're on the 6th day and you need to get it done, get that bid protest in so you have something in, right? So you have a placeholder at least. And then if it's talking about they've already done the protest, it was denied, what do I do? Again, I say, well, you as a contractor, you're allowed to file the notice of appeal with us, but that's it. You can't do anything else. You must be represented by counsel to appear before our board. And so our board is supposed to be, if you look down the list there, informal, inexpensive, and expeditious. And that is what we are, though from that aspect, because a company is not an individual, it's its own individual, right? It's not a person, it's its own person, its own entity. It has to be represented by someone. And in Maryland, you have to be an attorney to be able to represent anyone. So that's a little bit of a glitch in the informal part of it. But I think that, telling people, get your attorney on the case, get this thing in, don't miss a deadline. We want you to file a protest. We want you to file an appeal. Your issue may be something that we've never heard before, and it may be precedent setting. It may give guidance to someone else. And maybe you've come up with an issue that the procurement officer missed, and maybe it gives guidance to other procurement officers, our decision, that is. So I'm all about encouraging participation, and that is along those lines of fairness. So I think that in addition to that, one of the things that you touched on earlier, Chris, is that specialization. Right, boards like ours are specialized. You do one thing, and I remember the one major in MASH used to say when he first came on board as a doctor, and they're saying, hurry up, Winchester, hurry up, Winchester, and he said, I do one thing, I do it well, and then I move on. And that's sort of what it is. We do one thing, and hopefully by doing that one thing, we do it so well that we know the subject matter so well that we can move it expeditiously, as long as all the process flows smoothly. And you don't get, to a circuit court judge, and no offense to circuit court judges, but they have so many different areas they deal with. You can't be an expert in this thing that we do. And you're talking billions of dollars worth of taxpayer money spent every year in procurement in Maryland. So that's why it's so important. If it wasn't important, the legislature wouldn't have seen fit to create this independent body to resolve these issues. So I think that being able to issue opinions, as an expert body, gives us the opportunity to have these precedent-setting opinions out there that can be used as guidance. People can go on our website. You can search in the main Google search box. You can search by any subject you want, and every decision that we have since 1981, actually earlier MDOT decisions are there too. You'll be able to find any decision that has that word or that phraseology in it. And if you use a Boolean search, with the pluses and all that stuff, you can really narrow it down. And that helps people to understand what they're dealing with and how to prepare a case. It helps, I think, contractors. I think it helps also the procurement professionals. So if we want to move on to the next slide, I think that when we talk about process improvement, we can talk about the idea again that we get the worst of the worst, right? So we have seen just about everything. And once in a while, something new comes up and we go, man, that was really, how did it end up like that, right? So we would love to be able to set policy sometimes, but we know that that's not our job. Our job is to give everybody their day in court, give them a hearing, let them express their concerns, and to give everybody, again, that fair shake. So when we're looking at these things, we look at it and we say, what did the procurement officer do, right? Did they obey the law? Did they do anything that was arbitrary, capricious, contrary to law? And if they didn't, then you're going to have a hard way to prove that you should win that bid protest appeal. Frequently, this stuff is taken care of well before it gets to us. Lydia, I'm sure, has a better idea than I do, but protests are filed all the time. And we only see a small percentage of them because at the procurement officer level, things get resolved. If they don't get resolved, at the procurement officer level and they need to involve the attorney general's office sometimes then takes care of it. And then sometimes the attorney general, once an appeal has been filed, the attorney general's office and appellant's counsel get together and come up with some other resolution. So bid protests do occasionally get resolved without our intervention. But again, it's about seeing the worst of the worst. It's about kind of figuring it out. But the burden that an appellant has before us is kind of high, right? So they have to really prove that the procurement officer screwed up. And the board itself is very deferential. The board historically has said, we will not substitute our judgment for that of the procurement officer. However, we will look at it from a fairness angle, meaning, did they follow the law? Were you treated the same as other people? Was there something arbitrary there? Did the procurement officer do something they shouldn't have done? So in doing all that, we have to look to our guidance, and our guidance is a Code of Maryland regulations. So in terms of fixing what's broken, I have a lot of examples of that. The fix it, make it better process in Maryland, it's not just about our board. I'll talk about that first, but the state itself has done some pretty good things to try to get things in the right direction. We had to overhaul within the last few years our Code of Maryland regulations because some things were just out of date. Some citations didn't add up. They were no longer valid. But what we really wanted was consistency and accuracy. So we wanted to go ahead and say, what are days? Well, sometimes you see days, sometimes you see working days of state government, sometimes you saw even other terminology. And so in the bid protest section, everything outside of filing the notice of appeal, once that's done, that's calendar days, 10 calendar days. Once that's done, everything converts to working days of state government. So we went ahead and put a definition, and that said days means working days of state government. That way, when there's a state holiday, it doesn't count against you, right? It counts, the calendar days count through the weekend, but if Sunday's your 10th day, it rolls to the next day. When it comes to working days of state government, if you have something due in 15 days and you're on the 15th day, but that's a non-working day of state government, well, you roll to the next working day of state government. So we were able to make that clear. It's about accuracy, clarity for everyone. How many times did I see cases where the Attorney General's office would come in, or the Appellant's Counsel would come in, and they would say, well, this is what we think this means. But we didn't want any more of this is what we think it means. We wanted to say, this is what it does mean. And so we spent a lot of time overhauling our own regulations. And we don't have the authority to overhaul anybody else's regulations, though people have tried to do it to ours from time to time, and they were stopped in their tracks because it's just not allowed. You can only do your own agency's regulations. So again, consistency, accuracy. What we try to do is to get past this concept of delay. So when it comes to delay, delays slow the whole thing down. And I know you touched on that earlier, Professor. You talked about promptly, right? Promptly. What does that mean? Well, there was an issue of delay at the board where the agency report, which is basically the agency's version of events, it used to be due as expeditiously as possible, generally within 15 days. And time after time, I would have to call on behalf of the board to an assistant attorney general and say, when can I expect this thing? The board wants it. Not ever with Lydia, though. She was always on time and sometimes early. So you would have a situation where somebody would say to me, well, it says generally within 15 days, generally. And I would say, yeah, that part in parentheses behind where it says as expeditiously as possible. And it was just one thing after another. Either they had too much on their plate, maybe they just didn't think it was worth their time. I don't know, and I'm not criticizing anyone. There was one time though where it took 8 months for a procurement officer, for an assistant attorney general who was at the time anyway, I don't know if he still is, but he was principal counsel for a particular agency. And I called him no less than once a week and kept getting, oh yeah, I'm working on it. Oh yeah, I'm working on it. And again, I'm speaking for myself. I'm speaking from my experience. I'm not condemning anyone. I'm not saying it was necessarily intentional. But what I am saying is the board's charge is to do things in an informal, inexpensive, and expeditious manner. And so we had the responsibility to look at this and say, you know what? We can't handle this anymore. You've got to do your agency report within 15 days. And so we changed the Code of Maryland Regulations, COMAR for short. We changed it to say 15 days. Now, understanding that if there is a huge procurement and maybe there's tens of thousands of documents, you might need a little more time. File a motion. We're open to it. File a motion. But for now, it's 15 days. Beyond that, the Board of Public Works can always, if it wants to, award in the face of a protest. These delays slow things down. So when somebody's submitting an agency report late, or let's say there's some other thing that comes up, there's a motion filed and another motion filed, and it slows the process down. The Board of Public Works, if there is substantial state interest, the Board of Public Works has the authority, if requested, to award that contract in the face of the protest. So nothing happens without their authority. Now that, of course, as Lydia said last week, is based on procurements that are over certain dollar thresholds that they have authority over. But typically, the Board of Public Works, which is comprised of the governor, the state treasurer, and the state comptroller, they make all of those decisions as a panel. Typically, they hold the board in what I would consider to be high regard, because they rarely will award in the face of the protest. Not that they haven't done it, they have, but rarely. On the other hand, once they get our decision, if a party files a petition for judicial review at the circuit court, the Board of Public Works will not usually wait for that. They will move forward at that point, assuming that the board has done a good job. And typically, and I think Lydia would agree with this, typically the board's decisions are affirmed, even if it has to go up the chain a bit, special appeals or Court of Appeals. In fact, today, in one of our appeals, we were affirmed by the Court of Special Appeals. So we updated our website immediately to show that, because again, it's all about giving guidance and sharing that with the public. So motions I mentioned, we used to have a regulation that said if an assistant attorney general files a preliminary motion to dismiss, then that automatically stays the filing of the agency report. The problem is that the appellant gets 15 working days of state government to file an opposition, and then the assistant attorney general gets another 5 days to file a reply. So now we're talking a month. So now we're talking real delay. And so we would have those once in a while, and the assistant attorney general would always say, hey, can you give us an extension on the agency report? And we would usually say yes, and the parties would usually agree to that. But we changed COMAR thinking we were helping, and we put in this provision that said if a motion is filed, there's an automatic stay. And then what happened was, I'm going to say 85% or so of the time when a bid protest was filed, we almost immediately got a motion to dismiss. And so that started the delay process. So we had to take that back out of COMAR, because it's not our mission was to try to be efficient. We weren't trying to cause delay. And so again, going back to expeditious, we found it necessary to make an adjustment. And I think that that's sort of a common theme in procurement in general, is sort of you make adjustments as you go, you learn as you go. Discovery is another area of delay. In our procurement, so when there's an evaluation committee, the evaluators keep notes. And so forever, the appellant's counsel will ask for those evaluator notes. And 99 times out of 100, the board said, yeah, you could really use those. It's going to help you make your case. And so we would say, yeah, here's an order, hand them over. A lot of times the assistant attorney general would just hand them over, and we wouldn't have to do all that. But then there are some assistant attorneys general who believe that that's part of deliberative process privilege. And so you talked earlier, Chris, about this idea of being afraid of malpractice, and they don't want to make a mistake. So they're afraid to turn them over. Well, that again caused delay. So what we did was we adjusted COMAR to say, those are now, the evaluator notes are now part of the agency report. So you have to include them in the agency report. And of course, if there's a reason you feel like they shouldn't be in there, you can file a motion and we'll listen to you. But this sort of gave a little bit of relief, I think, to the Attorney General's office, at least for some folks, because then they felt like now it was out of their control. They didn't have to worry about it. They're just following the rules, right? And one thing I would point out is one of the things, and they made a very good point, is that you could have a chilling effect on that community of folks who do sit as evaluators if their names are out there. And so one of the things that we also included is that you have to redact the names of the evaluators on those notes when you turn them over. Moving along, other discovery disputes, there's always going to be some kind of thing that comes up. And again, motion to compel or something along these lines, there's delay. So what we started doing, we used to do this a little bit in the past, but within the last, say, year, what we started doing was having informal video conferences that try to deal with this issue and try to resolve the issue without the need for a hearing. And, we don't need a court reporter. We don't need all the back and forth. Let's just try to resolve this thing. And I would say that about 9 times out of 10, that's the result. We resolve it, it moves on, and we've saved a whole bunch of time because we didn't have to schedule a hearing and go through all of that stuff. So these are the things that we do to try to pick up the pace. I talked earlier about the sports wagering licenses. So that commission is SWARC, the Sports Wagering Application Review Commission, and a dedicated bunch of volunteers. And they also have staff provided by the Maryland Lottery and the Department of Legislative Services who are helping them, along with some consultants, helping them to create their regulations. We, as a board, offered, and they accepted. We said, we see the worst of the worst. Would you like us to take a look at those regs before you put them through for initial approval and then final approval? Would you like us to take a look just to see if we can find any problems down the road? and here's an example. They had in there that whatever deadline that SWARC comes up with for submitting an application is the last date that an application can be submitted. And we said, okay, where do you find that deadline? And they said, oh, it's going to be in the application. And we said, well, that's great. Then say the deadline created by SWARC that will be in the application is the final day, blah, 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 blah. Because COMAR, the regulations, that's what governs, not an application. So you've created an opportunity for ambiguity or a finding of something was arbitrary, something along those lines. So that was just one example, but it was such a great opportunity to be able to meet with them and try to fix it on the front end. Because if you can fix it on the front end, you avoid all the problems, or at least a bunch of them, down the road. So the last thing that I would say in that line is that we learn as we go. So nobody's perfect. There's always room for improvement. We try to be as good as we can be, but it doesn't always work out. So because it doesn't always work out, we look for constantly opportunities to write a decision that gives guidance so that if a procurement person, or if perhaps a lawmaker, were to read that decision, they might have a desire then to adjust the policy. We're not policymakers, but we can put those things out there in a way that fulfill our purpose and our mission, but that also offer an opportunity, if it falls into the right hands, for some change that could help. An example of what I'm talking about is there was a highly, highly qualified company that was rejected for a particular contract because they had chosen an MBE to work for them. That MBE was not certified. They were in the process. They were certified 2 or 3 days after bid opening, but the law said you had to be certified on the day of bid opening. And so we ended up, there's no wiggle room. It's not a minor irregularity. The law is the law. We ended up with a situation where by the evaluators, not by me, according to the evaluators, a lesser qualified firm got the contract rather than the higher qualified firm that actually had the better price. So the state, it was a lose-lose situation for the taxpayers and for the service recipients in terms of what the evaluators had to say. But it was a win for that particular contractor because they got a job. So it's just, sometimes it's tough. But in that decision, we said, well, we have no choice, as much as we would like to find for the appellant, as much as we would like to say, give the guy a little wiggle room. That's not our say. We don't get to say that. But we could say in the decision, had this been worded differently, had the law been worded differently, perhaps there could have been a window of opportunity. Perhaps this could have been treated as a minor irregularity, or there was a window of opportunity during which that MBE could be certified, right? So a little more flexibility to try to get the best result. That's not up to us, but I think that the state itself is constantly trying to find ways to make things better. In 2016, there was a task force to modernize procurement in state government. And this was run by the Lieutenant Governor, Boyd Rutherford. And I was fortunate enough to be called in with then Chairman Mike Collins to sit with the governor, with the Lieutenant Governor, and the entire panel and all of these other folks who came to be part of it. And the Lieutenant Governor and others asked us questions. How can we make it better? You see the worst of the worst. What's going on? And all of these things were things that we brought up. Not all of them, but a lot of them. And sadly, there were some people in the audience who I just saw shaking their head no. And it wasn't personal. For me, it was about fairness for everyone. It was about clarity. It was about an opportunity to do better and to make it better. And that is what I see my job as a member of the board, is to hear the situations, to apply the law, to make sure that there was nothing arbitrary, capricious, contrary to law, and to do it in a way that doesn't violate anything, but to do it in a way that ensures that everybody's heard. Everybody has an opportunity to be heard. So this task force put out a report, and it was a good report that had a lot of good information, and that, I think, was the catalyst that led to the creation of a Maryland Procurement Office. And we have a chief procurement officer in the state of Maryland. And unfortunately, that office doesn't cover all procurement in Maryland. For example, MDOT is excluded from that office. So they kind of have to do their own thing. And so they have a Maryland procurement manual now, which is intended to give people, again, clarity, uniformity, forms that are standard across the board, standard language for use, standard procedures for use, and policies. So it's getting better. It's getting better. I think we do a pretty good job as a state in general, the whole procurement process. I think that the procurement officials do a great job because, again, not many of these things make it to our level. But when they do, they're kind of bad. And I think that the folks who represent contractors before us do a stellar job. I think that the Attorney General's office, generally speaking, they do a stellar job. They come and they present their case representing that agency to the best of their ability. And I think that everybody's, from that aspect, everybody's heart or legal heart is in the right place. They're trying to, do the right thing. They're trying to be zealous advocates for their clients. And we just want to make sure that everybody gets a fair shake and everybody gets to be heard. So all of that said, I'm not sure there's a whole bunch more I can say, but I greatly, just like I appreciated the opportunity to deal with SWARC, I cannot emphasize enough and tell you how much I appreciate the opportunity for myself, for Board Member Kries, and also for our agency to be part of what you are doing, because this concept of a statewide platform, this statewide, nationwide consistency rather, is just spectacular. So thank you.
Oh, thank you so much. I had a chance while you're speaking to look through the participant list, and we have people from all over the world and all over the country participating this evening.
Great.
Really, I think it was really nice that they really important that they got to hear from you how seriously you take the rule of law and what it is that the board is doing. We're a little bit running a little bit late. We'll take a little bit of time at the end, so we have plenty of time with Jennifer and Tom and Ed. Why don't we take a 5-minute break now until 20 minutes past the hour, and then we'll come back and we'll hear from Jennifer. Thanks very much.
Thank you.
Hey, Jennifer?
Yes.
I'll advance the slides for you. We're ready to go whenever you are.
Okay.
Thank you for your patience.
Absolutely. Are we back on, or do you want me to wait a
We're
couple?
back on.
We're back on. Okay.
Ready to
All
roll.
right. All right. Great. Thank you. Well, thank you all thank you, Chris, for inviting me to speak, and you all for attending. Chris introduced me at the beginning. Just quickly, I want to note that my background is in public contract law, but I have the privilege of being able to represent both private companies and also some public entities, mostly local public entities here in California. But I think it does give me a little bit of a different perspective on public contract law and bid protests, because I get to see both sides of it. What I want to present to you today is just a few of the issues that I've seen developing in the California protest process and what's going on out here, and some areas that I see that the process could be improved. Now, for those of you who aren't familiar with California law, which I suspect is many of you, California is not a model procurement code state. So we very much have a background that is dissimilar in many ways to the model procurement code. And so, but we are one of, frankly, the largest economies. If we were a separate country, they say we'd be one of the largest economies in the world. And there's a lot of dollars coming through. So here's a couple of the issues that I have seen. The first one I want to talk about is obtaining documents. Documents are really critical for a protest. They are how you can assure transparency and accountability in the procurement process. They are also very interesting because I find that public entities often find disclosure of documents to be threatening, that a protest is a challenge, an accusation, if you will, of you did something wrong. And if I show you my documents, you might see what I did wrong, or you might criticize me. So there tends to be something of a reluctance sometimes to disclose documents. I will tell you from both sides of things that I have seen any number of protests that never happened because the public entity disclosed the documents. And once the potential protesting bidder saw what had been done, they looked at it and they said, you know what, there's not a protest issue here. Or they did the best they could. There's not something that is worth my time and effort to challenge. So it is not always a bad thing, even if there can be a fear that it is a bad thing. In fact, it's often a very good thing. In California, the way that you generally get documents is under the Public Records Act, which is essentially our equivalent to the Freedom of Information Act, or FOIA. One of the concerns under the Public Records Act is that a public entity has 10 days generally to respond to a Public Records Act request, and they can sometimes extend that time frame. Well, when you're looking at, say, a 5-day deadline to protest, that doesn't help very much. And so my clients, often the first time they'll come to me is with a concern of, how do I get the documents? How do I get the other bids or proposals so I even know if there's a protest issue? In some cases, we have statutes or regulations that will require that as soon as bids are open, they are public and they must be provided. So that is one way that people can get the public records faster. Now, when you move on to a request for proposals or solicitation, an award to generally the highest scored bidder as opposed to the lowest responsible bidder, some agencies at that point will refuse to disclose public records because of a fear of and I say fear, but a concern that they may go through the process and end up not awarding the contract, having to reject and rebid. And you don't want competitor A to have their proposal disclosed to competitor B, who then might be able to crib from it and get an advantage on a rebid. This is something we see quite frequently. And we do have a case that says, well, if you're in that evaluation process, you public entity do not need to disclose the proposals at that point for exactly that reason. But once you've decided who to award to, at that point, you do need to disclose the proposals. We do see a tug of war, though, on when exactly do the proposals need to be disclosed. And in any number of situations, I've been told by counsel for public entities that they will not disclose. They've made the decision who they want to award to and the recommendation, but they're not going to actually disclose until after the award is formally made, which at the local level is usually by, say, a board of supervisors or city council. And they often won't disclose until after the award is made, which is then too late to protest. So there's very much a tension there. And under the Public Records Act, there is an opportunity to go to court and challenge a refusal to provide documents, but that is not a fast process. And so it's essentially a non-remedy if you can't get the documents. What would I do in this situation? If I had the pen and I could change things, I would start the protest timelines after documents have been disclosed, at least certain documents that are critical to the ability to evaluate a procurement, the bidder proposal and the scoring records. You know, from a personal perspective, I once was told I had a protest that was due December 27th. I asked the public entity, would you please withdraw your notice of intent to award and reissue it so that I'm not working over Christmas to prepare my bid protest? And they said, no, we're not going to do that. I said, great, well, I need the documents. And they said, well, you can't expect us to give you the documents. We'll have to work over Christmas. So you see how this can play out. A second concern that comes up is confidential records. And often you'll find bidders that will mark documents confidential, sometimes with really legitimate reasons if they've sometimes been asked for tax returns or financial information that they don't want disclosed. But some will take advantage and mark, frankly, an entire proposal confidential, which leaves a public entity in a very difficult position when they're asked for documents to go through and have to decide, is it or is it not confidential? There, again, if I were able to make the change myself, what I'd say is that they really need clarity in any protest or procurement process. You need clarity as to what can and cannot be marked confidential. We do have that in some cases. There is a process in California called the pre-qualification process where bidders may be asked before bidding to submit financial information, insurance information, some of that background. And those documents are expressly not subject to the Public Records Act. But in many cases, that type of clarity isn't available, and it does cause confusion and it can cause delay. Another issue that I've seen with obtaining documents is scoring records. And again, this is generally on a request for proposals where you're getting a scored award as opposed to the low bidder. Often you'll find that there is no requirement for an evaluation and scoring report or record. So the only way that the bidders may know how the intended awardee was selected is by those scoring records. And the only way that you may be able to determine whether, in fact, the scoring criteria that were stated in the RFP were followed is if you can receive those scoring records. But many agencies don't retain them. And again, I think this is out of a concern not to be second guessed. Sometimes it's an iterative process as far as what's happening with scores. But what happens is if you don't have some sort of scoring records, in my experience, you will have, when you get to a protest, the attorney kind of creating what happened. So they'll respond to a protest and have an explanation, where when you get the documents, that's not there, but they kind of are backfilling. And it really is not, it doesn't promote that transparency and accountability if you're not asking the people who are making the determination, making the scoring decisions to document what they're doing. So solution, at least for larger procurements, would be to require that report to be put together as a condition of moving forward with award. So bid protest process. Here we have a number of issues that come up. So in California, at the state level, many of the procurements are overseen by the Department of General Services, or DGS. Recently, we have an issue where in the DGS process, especially with services procurements, the agency who's procuring the service will go through the procurement process, decide the intended awardee, but then DGS will hear any protest. They'll receive a notice of intent to protest, and then the protesting bidder files a detailed statement of its protest. Once that detailed statement is in, DGS will provide a timeline for the protest response, usually giving at least 2, sometimes 3 weeks to the intended awardee and the awarding agency to respond to the protest. And then it used to be that DGS would allow the protesting bidder a reply brief to respond to any arguments. One of the reasons to allow that reply brief is that sometimes the protesting bidder or the agency will raise a new issue in their response to the protest, particularly if you don't have that evaluation and selection report and there's an explanation of the scoring. But recently, in the past year, DGS has precluded, probably maybe 2 years, DGS has precluded reply briefs. And it does certainly expedite the process because once the record is complete, DGS has 30 days to decide a protest, and they often will take the full time, and the contract cannot move forward in that time frame. But it does really put the protesting bidder at a disadvantage, and it allows for overstatements or misstatements to be made in responding to a protest, with knowing that there's not going to be the opportunity for the protesting bidder to challenge the statement. Frankly, in a protest, an intended awardee, if they have a reason, the protesting bidder protests on the ground that they should have received the contract. If the intended awardee has grounds to say, no, the protesting bidder should not have received the contract, they omitted a document or they're not otherwise qualified, something along those lines, they should raise that in their response to the protest, and there should be an opportunity to reply. But at least as of right now, that opportunity is not being offered by the Department of General Services. And there is not a public hearing, or not an oral hearing at which the arguments can be made, because boy, maybe 25 years ago, I had an oral argument before DGS on a protest, but ever since then, they have decided to resolve the protests on the papers. And so really what's in writing is the last word, and it does leave a number of issues without the argument that frankly could help DGS in making a decision on the protest issues and coming to that neutral resolution. So I, as you can probably tell, would bring back the reply brief, even if it is on a very short time frame. At some levels, there is a lack of a specified protest process. This is often at the local level, and it's often where you have local entities that have less experience with protests and procurements. It can make it challenging because the bidders don't know time frame or what needs to be in a protest. The agency sometimes doesn't know, if they get a protest in, what to do in response and what the timeframes are there. And so it can be complicated. And what often will happen in those cases, if there is no protest process, is that the protesting bidder will show up at the city council meeting or board of supervisors meeting to try to address their protest without the kind of record and argument and advice that normally you would see in resolving a protest. And quite frankly, what almost inevitably happens in that case is that the public entity will go with what the staff recommendation was, even if there really was something that was missed in the intended award. So it does a disservice to the entity not to have that process set out. But it is something where when you have these entities that don't deal with a lot of procurements, it's something that often flies under the radar. And one of the comments earlier was something about whether anyone could protest or whether you have to be an interested bidder. And I will say at the local level, anyone can protest from the standpoint of they are allowed to appear and speak at those public meetings. And boy, I've seen a couple of union responses to protests that were vocal, extensive, and actually affected the outcome. So you do sometimes get that as well. One potential positive, and I'm kind of jealous of the Maryland system, is there are a few, and very few at this point in my experience, but there are a few local entities that do have an appeal process. So they'll have the contracting officer or somebody in the agency decide an initial level protest and then refer it up to say a supervisor or director, somebody who wasn't as directly involved. In my experience, this makes for a better process because you take it out of the feeling of a personal attack of somebody's criticizing me for doing something wrong, as opposed to we're all human and everyone misses things at some point. So it can take it out of that personal feeling and really give an opportunity for a more neutral review. But that only works if you really are giving the neutral review. If you don't have somebody who's going to do something other than rubber stamp what the people they're working with are doing, it is just a delay and a waste of time. And frankly, a potential, if the bidder does choose to challenge a protest decision further and go to court, potential to trip up there if they fail to appeal it. So an appeals process can be a very good thing, but it has to be done right. And that's something I would love to see California document and adopt more of an appeals process to resolve some of the issues before they have to go to court. Finally, we have some issues in California with neutrality. So again, staying at the local level, when you have those decisions that are being made by city council members, by a member of the board of supervisors, there is a constitutional right to petition government. So you can go as a constituent and speak to your elected representative and say to them, I want to tell you about this procurement, and I want to tell you what my thoughts are on the procurement and what you ought to do. Companies can hire lobbyists to go and speak to those same members and say, let me tell you what I think you ought to do. Unions most definitely hire lobbyists to go and speak to those folks. And so it is a constitutional right to do so, but it absolutely can impact the procurement because you are putting weight, you're putting pressure on certain members to vote certain ways. Hey, I live in your district and I voted for you and I've done this and that. And you really ought to let this go through or not let this go through. So it does have the ability to influence the outcome. For that reason, sometimes solicitation documents will prohibit outreach, certainly to the contracting officer or anyone other than the contracting officer during the procurement process, and sometimes to those board members before award. That is constitutionally problematic, but you will see it quite frequently as an attempt to deal with this neutrality issue of wanting to remove that pressure point. But quite frankly, and I will often tell my private clients, if they are protesting an award, if you protest and you get, particularly if you get the response from the local entity that says, you know, we're denying your protest, or we're recommending that the board deny your protest, the board's almost inevitably going to follow that recommendation. They trust their staff, they work with their staff. Often their staff are advised by their attorneys in the same way that your clients will listen, hopefully, to your advice, that public entities board is going to listen to their advice. When I talk to my clients who are public entities, I do hope they listen to my advice on what to do. And so it is difficult to get beyond that. And sometimes sometimes the outreach to those members is the only way to kind of get past that and have another look at it. So I have solution question mark here because I don't quite know what the solution is to this problem, but I think it is important to know, again, at the local level, that you need to be aware that this is an issue. The final issue that I want to address is California's alternative protest process. This is a process that is elected in some narrow number of procurements, which is, I think, a good thing, but it has a number of concerns and areas that I think should be considered for improvement overall. And I hope the Model Procurement Code Revision Commission will look at these types of issues. So in that process, the DGS is ultimately the procuring agency. So you protest, you file a notice of protest, and the DGS officer will initially look at your protest and say either, all right, I think you're fine to move forward, or I think that I'm making a preliminary finding that this is frivolous. And if they do that, the protesting bidder must file a bond of at least 10% of the contract value in order to move forward with the protest. And if their protest is ultimately found to actually be frivolous, and let me give you a hint, there's a very good chance it will be when they find it from the beginning, that bond is forfeit. It's not damages, it's just forfeit. So it essentially precludes you from proceeding with the protest. And I've had clients that have been in exactly that position. And I will tell you, I would never tell a client to proceed with a frivolous protest. So that will tell you where that goes. But if you move forward there, you get assigned a panel of potential, what they call arbitrators. And the arbitrators are almost entirely members of the Office of Administrative Hearings, which is a department within the Department of General Services. If you request a potential arbitrator who is not an OAH employee, you almost inevitably get former OAH employees who are fairly recently retired. The one or two times I've received somebody who was not a recent retiree, it was somebody who had no apparent background in procurement at all and was not someone you normally would select. And frankly, if you don't strike them, usually the agency will, and they're not available. So you're moving forward with somebody who is supposedly an arbitrator, but is an employee of one of the parties. This is not normally a huge issue if it is an administrative process that's subject to judicial review. But it's not. It is called an arbitration and it is treated as an arbitration. Normally, under an arbitration, your arbitrator would have to disclose any prior decisions and prior matters on which they'd served as an arbitrator. And you could strike them if you said, look, you have ruled in favor of this party far too often, or you've been arbitrating matters with them far too often. I don't think you're neutral. That critical opportunity is not available in this process. And it wouldn't be because, as I said, they are DGS employees, which would normally preclude them. And so you don't have the ability to challenge. But when you get the decision, it is treated as an arbitration decision, meaning that there are very, very narrow standards for challenging the decision in court. So it is an absolutely or almost absolutely binding decision. It has led to really some crazy decisions in my experience, including one, a number of them, frankly, where when you get the decision, it is amazing how the statements of law are word for word the same, depending on the arbitrator that's selected. So clearly there is a basis that they often are starting from. And one of the findings that is often made is relates to the weight of the evidence. And I have had any number of decisions where there's been a finding that the preponderance of the evidence standard wasn't met when the only evidence that was submitted by the protesting bidder. And the quote unquote evidence on the other side was simply a denial by the agency that, somebody saying that's wrong, but without knowledge of that. So it is a problematic process because I'm going to circle back to something that somebody said earlier, which is in a procurement, you need to have a sense of neutrality. You need to have the person who's deciding your protest be perceived as neutral and be neutral for the benefit of the procurement process as a whole. If you don't have that, you have bidders that are not willing to participate. You have bidders that will bid higher. You have monopoly opportunities that come in. That doesn't mean that you don't defer to an agency, because many, many times the people in the agency, I think probably almost always, they are doing their darndest to review bids and come to the right decision. And you have to give them the benefit of the doubt. But you have to have somebody who has the perception of, I am acting as neutral. There's the benefit of the doubt, and then there's too far. This process, I would say, goes too far because it takes out the opportunity for that review. But I'm sure I have now exceeded my time. I hope I have given you some idea of some of the perhaps quirky areas in California law and ways that we can hopefully improve them in the future. Thank you.
No, thank you very much, Jennifer. It actually opens up, I mean, what it opens up is the question is, how do we fix systems like this? And I actually get to meet a lawyer from DGS at one of the ABA meetings, Public Contract Law Section meetings. And I said, hey, the United States is a leading member of the UN Convention Against Corruption. Article 9 calls for an effective bid protest system. Does it bother you that California may be in fact violating the UN Convention Against Corruption? He just looked right through me. He couldn't care less. What's interesting is the UN Convention Against Corruption calls for peer review by other nations. So other nations come and look at the US system, and they always look at the federal system. What would be interesting for California and other states would be for that peer review to pierce down to the state level and say, hey, do you have effective bid protest systems at the state level? For instance, this stuff with the arbitrators, the biased arbitrators, the Germans have an arbitration system. It's called the Vergabekammer. It's an arbitration system, but it has a member of industry, it has an independent arbiter, and then it has a member of the agency. So you do have an independent arbitrator sitting on this arbitration panel, and those decisions are fully reviewable by the regional courts of appeal in Germany. So in open contracting, the idea that you can't have access to the record, open contracting, open government is the norm in many, many countries around the world. You can see everything all the time. Argentina, for example, you can see everything all the time. Why doesn't California, one of the leading economies, high-tech economies in the world, move towards that norm. So I think that kind of peer review through the UN Convention Against Corruption or through something like the UN Convention Against Corruption at a national level might be a way of prodding forward reform in what is clearly a broken system.
Well, and I do have to say there are a number of systems in California, and they're different at the different levels. And the one thing I didn't say is I do have to call out the California Department of Transportation, because at least for their protest process, because they don't have really a written protest process, but of all the state agencies, they have the best protest process out there. They really do. I don't always agree with them, but they really do attempt to look at issues neutrally. They have a separate board that looks at minority and women-owned business issues separately. So California really is very much a mix. And I do hope with model procurement code process, we can reach out and try to engage DGS, because I think that there are many people there who really are trying to do the right thing, but sometimes you need the help and guidance, and sometimes you need somebody to say it's okay to ask for that.
Yeah, and the thing about a bid protest system that isn't effective, if you look at Ukraine and what's happening in Ukraine, the legitimacy that the government built up before the invasion of February, the legitimacy they built up through a good procurement system, creates a reservoir of legitimacy, of goodwill that they are drawing now upon. Zelensky and his administration are drawing upon that reservoir of goodwill at a time of desperate national need. That reservoir, a state agency or federal agency can feel like, oh, we can squander the legitimacy. It's okay if we cut corners, but that draws down the legitimacy of the government overall. And that can be very dangerous in the long term if we have as a nation, if we hit a crisis point.
That is certainly true.
All right, gentlemen, we're going to go a little bit over, if it's okay, till 8:10 or so Eastern time. So you guys have a time to walk through your very important discussion of what's going on in Nebraska. So with that, I'll turn it over to you two.
Well, thank you, Chris, and I appreciate the opportunity to visit with you all. And I appreciate the prior introduction. My name is Tom Kenny, and I'm here with my partner, Ed Fox. We're both at the QTAC Brock law firm. And together we manage the firm's government solutions practice. We try to create solutions, and many times those solutions involve bid protests. In addition to handling protests in multiple states, we have been actively involved in the legislature, which we have a unicameral in Nebraska, where we've drafted legislation, we've testified on behalf of proponents of reform of our system, and Ed is going to tell you why it needs to be reformed. But so we have done that, and we also had the opportunity last year to participate in a special investigative committee process undertaken by the legislature in response to one of many contract failures that were really failures from not having an effective protest system, not having the right, an express right of judicial review. And so we're going to split our time, and Ed is going to go first and describe life in a state without an MPC and without a right of judicial review. Ed?
Wonderful. Thank you, Tom, for that. And thank you, Professor Eukins, for the invitation. And thank you to everyone who is a participant tonight. I was going to say good evening, but that may only be accurate for those of us in the eastern half of the United States, and maybe not for those around the world. But good evening from Nebraska, where Tom and I are located. So as Tom mentioned, we do bid protests in many states across the country on behalf of our clients. Our firm has 19 offices across the United States. So we have a footprint across the country, and oftentimes Tom and I are invited to participate in that. Tonight, though, of course, our focus is Nebraska. And of course, because of the timing, and wanting to get everyone off at a reasonable time, we will maybe push through a little quicker than we might have normally, but we'll try to get everyone out of here while still giving some information. I think it's important to note that the professor just in the chat provided some links to materials that Tom and I have created that relate to the topics we're discussing tonight. So if you want to get more in depth on these issues than we're going to be able to get in the next 15 to 20 minutes. Those materials are available for you in the chat. And then also, I think either Tom or I would be happy if anyone were to want to contact us directly at the law firm if you were to have questions. So Nebraska, as Tom mentioned, is both a non-MPC and non-judicial review jurisdiction. What that functionally means is that for purposes of bid protests in Nebraska, all you get is an agency bid protest. It only goes to the agency. There are only in Nebraska 2 levels of review within the agency. And at the end of that process, as far as the agency is concerned, the protest is done. There's no additional review. There's no opportunity to have that reviewed by a higher authority, by the courts, etc. And all of this, a lot of this derives because Nebraska actually has no statutory statements or no statutory requirements with respect to bid protests. All Nebraska statute requires is competitive bidding. It says any contract, and largely I should clarify, Tom and I are speaking about services contracts. Nebraska does have a slightly different system for goods as opposed to services, but the services contracts are the ones that we most often see the large protests in, at least in Nebraska. State statute only requires that all contracts in excess of $50,000 shall be bid using competitive bidding. And then the quote is, in the manner prescribed by the Division Procurement Manual or a process approved by the Director of the Department of Administrative Services. That's the extent of the competitive bidding requirements in Nebraska, and that leaves a lot of authority in the agencies themselves. Now, Administrative Services, which is our largest procuring agency, which houses our state purchasing bureau, has developed a procurement for a protest process along the lines of what you see on the screen in front of you, which is a very short administrative only process. Protests are due within 10 days. Responses are expected to be received within 10 days. Then you have another 10 days to ask for review by one higher level of authority. And then you get a response within 10 days, and that's it. There's no discovery rights. There's no hearings that are held. Witnesses cannot be called. No depositions can be provided, anything along those lines. And there's also no mechanism to stay the execution of the contract during that time. You can certainly ask, and Tom and I regularly do ask our agencies to stay the contract while they are reviewing our protest. And there is some language in the state procurement manual that suggests good practice would be to stay the execution of the contract, but that's ultimately within the agency's discretion. And as Tom and I have found, oftentimes the agency exercises its discretion and awards contracts prior to the end of the bid protest procedure. It should be briefly noted that in addition to the Department of Administrative Services, Nebraska law allows agencies to do their own procurements. For example, our Department of Health and Human Services is handling its own Medicaid managed care procurement, which is a multi-billion-dollar per year procurement that is being handled by the department itself, not our primary procuring agency. And it's being, the 2 levels of review, if you have a bid protest, are the COO for that department and then the CEO for that department. In other words, the people responsible for awarding the contract are the same people reviewing the contract, and there's no independent third-party review. DHHS awards the contract based off of criteria it establishes, and then it engages in its own protest. And at the end of that protest, as we list here, from the perspective of the agency, that's the end. If we could have the next slide, please, Professor. And what that means is that in Nebraska, at least, there's no appeal right after a bid protest. And this is something that we've found problematic on a number of levels, not the least of which are some very significant procurement failures that Nebraska has had, which I believe that Tom will probably speak to a larger degree. But Nebraska does not have any statutory right, and there is no particular right of judicial review built into the protest process. Generally speaking, the Nebraska courts have found that disappointed bidders do not have standing to sue in court in order to challenge a bid protest award. There are a couple of names we have listed there, Rath and Day versus City of Beatrice. Those are key Supreme Court decisions in Nebraska that have held functionally that, and I'll quote actually from Day versus the City of Beatrice, an unsuccessful bidder has acquired no legal right to protect, either in law or equity, since the letting of contracts to the lowest bidder is regarded as being for the benefit of the public and not for the bidders. So bidders have no standing to sue as a general rule. We've obviously tried to find exceptions to that, we have not been terribly successful thus far. And then the other, but the way we typically then try to protest in court or try to challenge an adverse protest decision in court is using taxpayer standing. Now, this can either be through the entity that we represent, if it's itself a taxpayer in Nebraska, or it can be an individual Nebraska taxpayer, maybe who's a board member of an entity that has some interest in the outcome of the procurement, or something along those lines. So we do occasionally get a chance to have the procurements reviewed in court using taxpayer standing, but even when we're able to do that, the standards that Nebraska courts have applied to such challenges are extremely narrow. For example, the primary standard as it applies in Nebraska comes from Rath, the decision that we mentioned, that I mentioned previously, and it says essentially that an administrative body, when exercising its judgment, acts from honest conviction based on facts as it believes the best interest of the entity, and where there is no showing, and this is the key phrase, no showing of that it acts arbitrarily or from favoritism, ill will, fraud, collusion, or other such motives. If there's no bad motive, then the courts will not disturb the protest, or will not disturb the contract award, irrespective of any other issues that we might identify. And as the legislature in Nebraska recently determined, there are a lot of errors in the Nebraska procurement process, and there have been a lot of multi-million and billion-dollar failures in the Nebraska procurement process that continue to persist and have led to the push that we've been making to try to alter the Nebraska procurement system, which I'll let Tom speak a little bit more about now in effort to speed things along. Thank you.
Thanks, Ed. And don't get us wrong, we don't want to be critical of our home state of Nebraska. It's a fine place to live. But with regard to bid protests, there are some major issues. So if by way of comparison, Nebraska versus Iowa, Iowa's border is about a mile from where I'm sitting right now in Omaha across the river. If your protest happens, your client is in Iowa and happens to have a challenge. In Iowa, they have not adopted the model procurement code, but they do have some procedures. They have a written notice of appeal within 5 days of notice of award. There's a deadline for conducting a evidentiary hearing before an ALJ. There is a forum to seek a stay of contract award, and there needs to be a showing made that would justify a stay of the contract award and execution. Fairly wide-ranging discovery, depositions, witness testimony, etc. None of those things are available in Nebraska. In Nebraska, our discovery rights are really through our Open Records Act, which sometimes provides us information in time for us to meet the 10-day clock on filing a protest. Sometimes it doesn't. In Iowa, there's a hearing held with a proposed decision by the ALJ and a final by the director of the agency. And then there is a right to a further appeal under their Administrative Procedure Act. So it's a very different system, although it's not very far away geographically. And the procedural protections in Iowa, I'm not going to say always are going to change the outcome of the protest. But there are significant values, and Professor Eukens has identified some of those in his comments, as have other of the presenters. One is that they provide a fuller evidentiary record and support for the agency's decision, or identifying flaws in the agency's decision, which is beneficial, I would argue, to both the bidders and the agency. They give the unsuccessful bidder their day in court, which has enormous value to the bidders, and as does the perception that they are given their day in court and being able to discover the factual basis for the award decision. And we have found and looked at this and testified about, what effect on the market does it have to spend $1 million in a managed care procurement, for example, which happens, and then if you have 2 meetings and a letter, and you're done, and with no understanding of the process. So I think there is value, even though it may not change the outcome in our neighboring state of Iowa. I think there is value to having the procedures in place that they do have. And I think it enhances the agency's credibility and the credibility of the award and the ultimately successful awardee. I think also, obviously, the opportunity to have the facts and analysis and the arguments reviewed and decided by a neutral judge has enormous value, I think, to all stakeholders in the process. And without that, I think it discourages, and we've had clients tell us, we're never coming back to Nebraska because we got hometown, we don't understand the decision, we don't have any rights to gain an understanding of the decision. So I think there is great value to having the APA process that Iowa has, and even greater value for a model procurement code system to be adopted in Nebraska. So if we go to the next page, I want to just touch very briefly on some legislative reform efforts. Ed and I and others in our firm have been very active in efforts to reform our system and to in fact have a system for bid protests. There have been 2 bills that were introduced going back 5 years. There's for the last 5 years, there have been active bills, hearings to consider a very minor reform, really. It's legislation that Ed and I helped draft that would provide one right, really, and that is for a judicial review in Nebraska. So, and there are ALJs within our agencies. There is the infrastructure for a administrative review and hearing like you have in Iowa and many other states. If you're a Medicaid beneficiary and you lose, a $100 walker, which is very significant loss for anyone who needs a walker. But if you've spent $1 million bidding on a contract in Nebraska, you don't have that agency right to, you don't have a right to an evidentiary hearing, and you don't have a right to judicial review. So the legislation is really a baby step towards reform. But even that baby step has not crossed the threshold into enacted legislation. In the middle of consideration of these bills, LB 61 was pending the last couple of years. There was another really a massive procurement failure that Ed and I were involved in the protest in that case, and involved a $375 million child welfare contract. And it, as we predicted in our protest, and in that protest, we were successful in going from the agency. We used a taxpayer standing argument. We got before a court. We had a TRO hearing. The court found that we didn't have sufficient evidence. This is all happening very quickly, that we hadn't developed sufficient evidence. We didn't have the right to depositions, et cetera. Court denied the TRO. Contract blew apart. 18 months later, the legislature had to appropriate an additional $175 million to the winning bidder to allow it to complete the contract that it said it could complete at $175 million less. And so that led to a legislative resolution 29, and that was a legislative investigation where they investigated the circumstances of that child welfare contract failure and several others. And we assisted in testifying for the legislature and in drafting a report that's linked here that looked at just a couple of prior procurement failures and recommended that there be further study conducted. It's interesting to note that the administration in Nebraska has opposed reform for 2 reasons, really. They have something called a cost estimate that accompanies the legislation, and the concerns are, one, that having a more robust or having a judicial review or administrative hearing process would add to the cost of procurement. They've estimated that to be $200,000 a year additional cost from having that very limited review, and that it would delay the procurement process. it's interesting to note, or frustrating, I would say, to note that the estimate of costs that's provided to the legislature does not account for the $60 million contract failure that's noted in the report, or the $300 million contract failure that's noted in the report. That is not included in the administration's calculation of costs of having a reform in Nebraska. So that's very frustrating. I think the costs we've touched on are very significant, and not having what's perceived to be a fair process. And it's not only that perception that is a cost, it is the cost of contract failures and hiring unqualified bidders. So what has occurred since then is that there has been a consulting firm by the name of ICASO Consulting that is going to prepare a study of not only the statutes and the regs in Nebraska, but the vendor's manual and all the tools that the agency currently uses to conduct competitive bidding in Nebraska. So that's where we are. I think the timing of the model procurement code is really ideal, because I think it will be coming to fruition at the time that Nebraska is completing its consulting review, or maybe the timing isn't going to be exact, but it's a wonderful exemplar to provide to our legislators about how it should be done. And they've received numerous examples of how it shouldn't be done. And so we're hopeful for the future, and we're going to keep along with all of you on the panel and others in advocating for a fair and even-handed process in our state. And I very much appreciate the opportunity. Again, if anyone has any questions, feel free to contact us or use the chat line and post questions.
Thank you very much. We got a question from one of the other panelists. With the limit on the legal process used in Nebraska, does that mean that lobbying efforts become the primary ways to challenge or influence the procurement decisions and the contract awards?
Well, I can start to answer that, and I'd appreciate Ed's thoughts. It's hard for us, so we have, as most states will have, a no contact rule during the procurement. Lobbying efforts, so I can't tell you for certain because I haven't detected the fingerprints on the other side and whether their efforts have been successful. I know that is an avenue that is attempted. I think it's difficult when you get into this quasi-legal process, which is our paper administrative process, to exert that sort of influence. The legislature really has no direct impact or input into an award decision, and it moves pretty quickly. So if you have an effective lobbyist that can get to the right person, I think that is a potential alternative that can be exercised, has been exercised. I can't tell you that it's been successful in our case or in other cases we're aware of where other bidders are doing that.
Let me close out by asking you. So I work with professors all over the world, including some professors in countries that are authoritarian nations. And so I learned from those other professors that sometimes my job as a professor is to ask the obnoxious questions to try to move the process forward. So here's the obnoxious question I'd like to close out with you guys. Here's my emerging theory as I'm an aging procurement lawyer. I think that procurement officials resist bid protests and bid challenges aggressively, like we saw in California, like we're seeing in Nebraska. They resist them because their power, their sense of power, their sense of self-power comes in part from precisely from their ability to make stupid decisions. That gives them power. And if you puncture that, if you can bring bid protests, their power is depleted. What do you think? And Lydia, you're welcome to weigh in on this because it's an important sort of psychosocial issue. What do you think?
Well, this is Ed, and I don't mind saying that I think that you've touched on something that, at least in Nebraska, I think has an air of certain amount of truth to it. The agency's opposition to change seems to be opposition to any change. It doesn't seem to be necessarily opposition to our change. And it seems to be opposition to anything that provides a third party's opportunity to influence the decision-making process. I will say, and this is certainly not to speak about any particular individual, but the normal procurement process in Nebraska for the non-agency, so if you've got the Department of Administrative Services, the final arbiter in that case is the director of that department, and that's a political appointee. That's a member of the governor's cabinet in Nebraska. And I think that also creates incentives that don't always, you would think that there would be incentive there to have good contract governance and only for the best contract results, but that's not necessarily true when you think about the timing and the temporal nature of these contracts, some of which the faults might not be happening into the future until you have a new administration. And so sometimes showing weakness or suggestion that there was something done wrong on the front end may be perceived as being more troublesome than the idea of a contract failure that may happen sometime down the line. So I definitely think that in a situation like ours, there are certainly those other incentives that come into play that maintain the system as they are and are great resistance to reform. And the only other note I would make just briefly on the lobbying question, and I agree 100% with what Tom said, but one thing we do note on our end as advising our clients pre-procurement is that lobbying often now takes place in advance of the RFP to try to get RFPs written in a way that may advantage a certain bidder or a potential provider of those services. So we actually have lobbying now where we'll have entities maybe pushing on the front end with the agencies and communicating with agencies, trying to help tailor RFPs in a way that may provide them with some advantage. And so that's become, certainly a big lobbying effort, or an effort where we may see government services and lobbying.
Yeah,
I would add, I just want to follow up on Ed. I agree with Ed's comments completely. The other thing in terms of human nature, the DAS director, who is not required to be a lawyer and has not been a lawyer for 12 years, for him to grant a protest is for him to criticize his own staff that directed the evaluation and directed, the award decision. So it's, in a sense, it's arbitrary power that is exercised with few or no constraints in terms of what the law says, but also in terms of self-preservation unless there's fraud or something that he can point to wrongdoing by a bidder. If it's anywhere in the evaluation process, something they missed, then he's criticizing his own staff and really himself. So I think that's part of it as well.
In Burma, they have a procurement system. It's been a military dictatorship since 1960. During the 1960s, since the 1960s, in Burma, they have a procurement process where you go through the technical and price evaluation, and then it's like a lateral pass in football. They lateral pass off to a junior political, and the junior political makes the final decision. If that's crazy in Burma, wouldn't it be crazy in our country too? Jennifer, did you have a comment?
Yeah, I just was responding to your question about power, and I think that is true in some cases, but I think that what I see is you tend to have people working for public entities who are trying to do their jobs, and they need to buy services, they need to buy construction, they need to buy products to make their jobs work. And often they need to buy those things in a certain time frame. Either they're losing federal funding, or they've got to open a school, or whatever it is, they've got this timing. And sometimes that means that they get things out on the street when they haven't really thought all the way through it. Sometimes they realize it after they get the bids or during the bid evaluation process. And it may be a power thing, but I think probably the more common reaction is somebody looking at it and saying, oh my God, I've got these things. I can't go back out to bid. I don't have the time. I don't have the resources. What a headache. Don't make me do this. And so I think what I've seen is more of a reaction to a protest is don't make me go back and, dot the i's and cross the t's and do it the right way. And it is the nature of the public procurement process that you have to dot the i's and cross the t's. But I feel like that's more what I see is the practicality versus the i's dotted and t's crossed that you tend to see the resistance.
So can I chime in just a little bit? I'm going to stick up for some procurement officers a little bit. I think that procurement officers have extremely difficult jobs, and it's very hard to do something that somebody like the experts on this panel would look at and say, oh gosh, that was a perfect procurement. What I have seen is, sure, procurement officers might they might say, why did they protest? Why are they accusing me of doing bad things? But I think to add on to what Jennifer had said is that at least in Maryland, the way that the procurement system is set up is that the procuring agency generally procures the services that it needs. The procuring agency has a procurement officer, and then above her, there might be several levels, and at the very top, maybe there's a secretary. If it is a very important contract, there are going to be time pressures, there are going to be funding pressures, there may be political pressures. And I think that sometimes there is a concern about boss disapproval. And I think that it can be hard sometimes for a procurement officer without the support of perhaps the Assistant Attorney General who's assigned to her to say, I think maybe something went wrong and we need to be able to correct this or do something. I think there's just a lot of pressures on people who are normally really trying to do the right thing and trying to get the right results.
Thanks very much. So Mike, you have a comment, and Ed, you want to close this out? Go ahead, Mike.
Yeah, thank you very much. I just want to kind of dovetail onto what Lydia was saying, and that is that procurement officials in Maryland generally do such a great job that so few of these things ever make it to our level. So they are committed to the process. When they do come in, you can tell how genuinely disappointed they are that there was a problem, and they will go to great lengths to explain how and why they did what they did, in the hopes of conveying to us that it was, even if they made a mistake, it was honestly just a mistake, right? And sometimes they really believe that even if we find it to be a mistake, that they don't think it was a mistake. Now, another thing I wanted to say was that the procurement officers sometimes are completely overwhelmed. They have way too many projects going on at one time, and or they can be new. And if they're new and they don't have the right training, it can be very intimidating. It can be very difficult for them to know how to respond to something. And they may even be intimidated by contacting the Assistant Attorney General assigned to their agency. So there's a lot of factors there. It's not just cut and dry simple. And I give credit to anybody who wants that job, who is willing to dig in, do what it takes to get it done, because it's a hard job.
Great, and I appreciate the chance to close out a little bit and also to clarify a little bit. I wanted to, nothing that I was saying was intended to criticize the actual procurement officials doing the procurement. What I was referring to was the resistance to reform in a state like Nebraska, where we do not have a system along the lines of what Maryland has, which I'll admit right now, based off of just the hour today, I'm incredibly jealous of, because I think what we need is, the issue we have, I believe, in Nebraska is a lack of independence. And that lack of independence, I think those who receive a benefit from maintaining that kind of grasp on that power and not having oversight of their activities, and that's not the procurement officers I'm talking about, that's usually the leadership in the procuring agencies that resolve bid protests and want to have the opportunity to be the final arbiter of those bid protests without having a third party looking at them. In Nebraska, we've had significant contract failures, and those contract failures oftentimes were caused by things that were not the procuring officer's faults. They were, for example, the large one that Tom mentioned with the child welfare, it was an underbidding problem. The entity underbid, and it admitted later on that it underbid the contract, and it underbid it by a factor of 50% of what the other bid was. There were only two bidders. One was 350 million, one was 175. And because the way the scoring was set up, that automatically made them the highest scoring bidder in the evaluation process. And what we lacked was any courage of anyone to say that price is not a real price. That's not what can happen here. And ultimately it hasn't happened. They canceled the contract, and those child welfare services that had been privatized have now been taken back by the agency and are now back in the state's responsibility, which was contrary to the original plan. So just wanted to clarify, I realize and I understand, because we work regularly with the procurement officers, those individuals doing the day-to-day work of making sure the RFPs go out, making sure questions are answered, making sure that the Q&A process goes through effectively. Certainly, I wasn't suggesting that those individuals are power hungry. What I am suggesting, though, is that there are incentives in a state like Nebraska that lacks the type of process that you have in Maryland, or that lacks the type of process envisioned by the MPC, that prevents us from adopting those, and prevents us from adopting even the minor change that Tom and I have proposed through the legislation we mentioned, which only would apply to contracts over $5 million. We can't even get judicial review just on that 1% of contracts we do a year that exceed $5 million, because there is resistance to that from the governor's office and the agency heads who happen to be political appointees, et cetera. So that was, I think, and that's how I interpreted the professor's question about resistance to reform, as opposed to, the everyday procurement officer, which certainly was not, certainly my intent to suggest otherwise. So I just wanted to clarify that to make sure everyone was speaking, kind of on the same page about the same topic.
Thanks very much, Ed. So thank you. We've gone over time. Our audience is usually indulged us. So I appreciate all of you for hanging on. Thanks very much for being here, Mike Beavis, as well. He's going to be a very important part of the MPC reform effort. So thank you all, and have a very good evening. And for those of you who'd like to join us on Thursday to see old Professor Eucken stumble through an argument, that'll be fun. We'll have that mock bid protest Thursday, same time, 6 to 8 Eastern. Take care all. Thanks again.
Thank you,
Bye-bye.
Professor.
Bye-bye.
Thank you. Thanks.
Thanks. Bye-bye.